Hi, Steve Carlson here. Welcome again to my U.S. Senate Free and Fair Election site. I hope you have had a chance to view the many issues on all my scores of YouTube videos here and some text covering the entire range of issues that concern the American people in this election. Fearlessly, because these issues are real and we need to educate ourselves about them and we need action. I don't mean big government solutions. I have real solutions. How to secure the border and really reform immigration and education. How to get rid of Obamacare and really reform health care. How to fix the achievement gap and exclusion in Minnesota and reform education. How to relieve the Minnesota households of consumer debt and create millions of jobs in this nation, of which Minnesota will be a leader. How to reverse the direction of the federal debt and empower the 50 states. How to defend ourselves in the world, and how to stay true to our religious liberties. This subject is far beyond the ken of Al Franken, Harvard or not, and a Mike McFadden or an NPR. But you can watch it and tell me on Twitter what you think. And go out and vote, and go out and lead and save our nation. Yes, I am the Tea Party. You are the Tea Party. You have this calling, as do I. I argue that the 2004 Moore decision of Ramsey County Judge Michael Monahan was not warranted by the law at that time or at this time, since the state, here the state of Minnesota, has the power and the duty to regulate its elections according to its laws and the U.S. Constitution, with some regulation by Congress. And certainly this should not be applied, Monahan's decision should not be applied to justify the season-long debate exclusion of the Independence Party in the Senate race by the two parties and the use of 3 different FCC licensed broadcast facilities. Further, NPR and the media generally have directly engaged in viewpoint discrimination against me because I am a Tea Party candidate for U.S. Senate, because some of the views that NPR specifically, both Mike Mulcahy, their news director, and Tom Scheck, their reporter, have very falsely and injuriously attributed to me. The issue is not whether the First Amendment protects their malicious comments, but whether, when they claim an editorial right to exclude me from their publicly broadcast debate as an FCC licensee, they are engaging in impermissible viewpoint discrimination as well as trespassing on my First Amendment rights of political expression and political association. My argument is grounded in the U.S. Constitution, and that Constitution's assignment of duties of sitting Minnesota Supreme Court judges. We're talking about Lori Gildea. We're talking about David, the guy who's running against, he was Al Frankenstein, David Lillyhout. These people to enforce the elections for U.S. Senate through their omnibus election jurisdiction, so that these broadcasts and the Democrats and Republicans these broadcasters will at last comply with the U.S. Constitution. Now, this duty of the Minnesota Supreme Court grows out of Section 4 of Article 1 of the United States Constitution, which declares that, quote, the elections for senators and representatives shall be prescribed in each state by the legislature thereof, unquote. That means what is prescribed must be enforced. And of course, they have to comply with the Constitution and the Congress. And as I say, I don't doubt that these elected judges, you've made some bad choices, and most lawyers are simply ignorant of this duty. And they think that they can just freelance on congressional elections and trade with their buddies who appoint them, people like Al Franken, Amy Klobuchar, and of course Governor Mark Dayton. So they need the guidance of the U.S. Supreme Court, and now is the time for that guidance. The future of the independent voters and the Minnesota Independence Party is at stake, and basically democracy in this state and actually in this country is at stake. You'll see what Franken did can be engineered all over the country, and we'll never have a third party included in debates unless it's for show. The time for change is now. I'm Steve Carlson, I'm approving this message as I continue, and this is the second video called Minnesota's Constitutional Duty to Hold Free and Fair Elections. It starts with the case Ex parte Yarborough about black voters who were physically intimidated in Georgia so they would not try to vote in federal elections, the legal framework for publicly broadcast debates in Minnesota, and a summary of my argument to the Supreme Court. This was actually submitted to Justice Breyer on Friday. Movement starts with the U.S. Constitution, citing Ex parte Yarborough. That's 110 U.S. 651 from 1884 if you want to look it up. In that case, the Congress passed a law calling for punishment of those who assaulted black voters in a congressional election to intimidate them. The state of Georgia objected, and Justice Stephen Miller set out in his opinion just where the power of the states to prescribe and implement federal elections comes from in the U.S. Constitution. He starts with the motive, quote, "If this government is anything more than a mere aggregation of delegated agents of other states and governments, each of which is superior to the general government," talking about the federal government, the federal government must have the power to protect the elections on which its existence depends from violence and corruption. If it has not this power, it is left helpless before the two great natural and historical enemies of all republics, open violence and insidious corruption," unquote. These great enemies are present in the new Minnesota landscape that I mentioned in my first video, which is the phrase NPR used after Paul Wellstone was killed tragically in a plane crash, and it left just a 6-day window to elect a senator, and he was leading in the election, and Walter Mondale was kind of rusty, and the Democrats and NPR, I think, wanted him to jump in and have the chance for the voters just to size up Mondale versus Coleman. And they changed their mind in the middle of that new election landscape and kicked out James Moore, the Independent Party Senate candidate, and they brought this case called Moore in the Ramsey County District Court before retired now Judge Michael Monahan. And so, as I was saying, these great enemies of violence and corruption are present in the new Minnesota landscape. Corruption has emerged in the aftermath of this violent tragedy involving Senator Wellstone and his family. And it is only expanding because the Minnesota courts are allowing it. This includes the Minnesota Supreme Court. And this motion to the United States Supreme Court, a single justice, Justice Breyer, asked the court to declare that Minnesota must restrict and curb this abuse of the public broadcasting facilities in U.S. Senate elections. The Constitution recognizes the right for derivative powers in the Constitution, quote, "by conferring on Congress the authority to pass all laws necessary and proper to carry into execution the powers expressly granted and all other powers vested in the government or any branch of it by the Constitution." This is Article 1, Section 8, Clause 18. Here, these derivative powers reside in the state of Minnesota as well, its legislature and its Supreme Court, because of Article 1, Section 4. The immediate object in this motion, as in Yarborough, is the right to vote for Congress, expanded to Senate elections by the 17th Amendment of the U.S. Constitution. Section 4 of Article 1 of the Constitution declares that, again, the elections for senators and representatives shall be prescribed in each state by the legislature thereof. Here, the Minnesota legislature must be enforced by the Minnesota Supreme Court, and the Minnesota legislature has given them that power in its elections petition statute. That's Minnesota Statutes 204B.44. This implies as a derivative, as I said, the power and duty of the Minnesota Supreme Court to enforce that law, because that court has the power and duty of to enforce the state voting qualifications and conditions. Now, as in Yarborough, it implied a right not to be beat up on the way to the voting. Here it implies a right to be informed by an election held under the regulation of the First Amendment, U.S. Constitution, and also the equal time provisions. The U.S. Constitution, quote, adopts the state qualification, that's whatever the legislature prescribes, as the federal qualification for the voter. And I'm quoting now from the Yarborough case. But his right to vote is based upon the Constitution, that is the U.S. Constitution, and not upon the state law. And Congress has the constitutional power to pass laws for the free, pure, and safe exercise of this right. Remember that phrase, free, pure, and safe exercise of the right to vote. That is the duty of the Minnesota Supreme Court. And no matter if they think they're above the law or they're friends with the candidates of the two duopoly major powers, Democrats and Republicans, doesn't matter. This is their duty, which they have abdicated irresponsibly and incompetently. Now, in the case of Minnesota, our Constitution at Article 7, elective franchise does also provide a state constitutional basis for the vote. It is important to note that the Communications Act of 1934, Section 315, which provides for equal treatment of ballot qualified candidates, must be read in light of this free, pure, and safe exercise of the elective franchise required of the statute at issue in Yarborough. And it must further be read in light of this court's description, this is the United States Supreme Court, of the application of the First Amendment in Buckley versus Vallejo, which I raised immediately with the Minnesota Supreme Court. Now here's the Minnesota legislative prescription of election of U.S. senators. This is what, under the U.S. Constitution, the Minnesota legislature has prescribed. And this is binding. So far as I know, and I'm not a lawyer, the statutory framework for this law is in Minnesota Statutes 204B, which includes 204B.44, but also includes 204B.03, manner of nomination. Candidates of a major political party for any partisan office except presidential shall apply for a place on the primary ballot by filing an affidavit of candidacy and shall be nominated by primary. And so I have been nominated by a primary. Now it states that candidates for any partisan office who do not seek the nomination of a major political party shall be nominated by nominating petition. That's really not at issue in the case that I'm raising. And also relevant, 209.12, congressional office. After the time for appeal, or in the case of an appeal, after the final judicial determination of the election contest, upon application of either party to the contest, the court administrator of the district court shall promptly certify and forward the files and records of the proceedings with all the evidence taken to the presiding officer of the Senate, not to the Minnesota Supreme Court, because no Minnesota court can void an election or block a contest, but this Minnesota Supreme Court did. And that was relevant when I did file an election contest on some other issues which are about to come before the U.S. Supreme Court. That is the withholding of voter email addresses, which Mark Ritchie, as the DFL Secretary of State and highest chief election officer, takes home to his home from the Secretary of State's office and raises funds for his campaign for other Democrats. This is how corrupt this state is. Here's another relevant statute, 204B.44. That's the one I proceeded on at the Minnesota Supreme Court. Errors and omissions and the remedy. Any individual may file a petition in the manner provided in this section for the correction of any of the following errors, omissions, or wrongful acts which have occurred or are about to occur. D. Any wrongful act, omission, or error of any election judge, municipal clerk, county auditor, canvassing board, or any of its members, the Secretary of State, or any other individual charged with any duty concerning an election. That includes Lori Gildea and all the sitting judges of the Minnesota Supreme Court. The petition shall describe the error, omission, or wrongful act and the correction sought by the petitioner. The petition shall be filed with any judge of the Supreme Court in the case of an election for state or federal office, and the U.S. Senate is a federal office. It was correctly filed with them. I properly filed this petition with the Supreme Court, Minnesota Supreme Court, because it was for federal office. But the court refused to recognize and address it because it was not about balance. It did not challenge the actions of the Secretary, Mark Ritchie. However, the law says, again, any individual charged with any duty concerning an election, unquote. I assert that respondents are just such individuals. That is to say, Esme Murphy of WCCO CBS TV, she's an individual, they're the respondent. She's a political anchor, Sunday morning anchor of that station, and was the moderator of the U.S. Senate candidate debate, so-called. And Mike Mulcahy, news director of NPR, who is in charge of the U.S. Senate candidate debate scheduled for tonight in approximately 1 hour, and formally requested to participate and showed my credentials as a ballot qualified candidate, and they refused and went ahead, or are going ahead, without. I will show below that this follows from the case CBS versus DNC, Democratic National Committee. I'm saying it follows that they are any individual charged with any duty concerning an election. And that CBS case was cited by CBS Broadcasting in my case, and was cited by John Borger representing NPR in a 2002 Moore case. And it is, the quotation, if you want to look it up, is 412 U.S. 94 from 1973. Now, the court below, that's the Minnesota Supreme Court, erroneously asserted that she did not have jurisdiction to review the FCC disposition of my FCC complaint. However, such a decision can be reviewed for abuse of discretion, and I assert that the FCC is abusing its discretion. However, for I also wanted to preserve the equal time statutory remedies, quote, the role of the courts was limited to review and enforcement of commission decisions and orders under an abuse of discretion standard. That's from FCC versus RCA Communications, 346 U.S. 86 in 1953, and it was cited in Beluso versus Turner Communications, 633 Fed 2nd 393 from the Fifth Circuit at 15. That's from 1980. Now, pursuant where it says, this is the Fifth Circuit, this is the one that's down in Texas, federal appellate court. Pursuant to its statutory authority, the commission has promulgated rules and regulations which provide a candidate aggrieved by a violation of Section 315A, that's the equal time provision, an administrative remedy. And this includes the general complaint procedures, 47 CFR, Section 1.1 from 1979. So in 2012, going back to this one that's coming up before the Supreme Court about email petitions and quotas in the DFL, which involves several of the same issues that I again brought in the 2014 petition because they were never addressed, but not including exclusion from debates. The 2012 case did not. Movement first filed timely an election contest. The state district court refused to proceed because they said I needed to pay a fee of $350, which would be paid to the state's general fund, which I could not pay. And the matter was brought to the Minnesota Supreme Court on this election petition, who refused to allow the contest to proceed, saying an election contest was not, quote, concerning an election, unquote, just because it had the word election in it. It concerned something else, according to Lori Gilday and the rest of these folks that you've elected to the Minnesota Supreme Court, or really have been all appointed by governors because supposedly they couldn't wait till the election, and then you just ratified it because you don't know what's going on. Now, as such, Movement asserts that by blocking the contest, they not only violated Minnesota Statutes 209.112, or point 12, which I've said above is about federal elections, they also usurped the power housed in the U.S. House by the United States Constitution. Article 1, Section 5, Clause 1, every house or each house shall be the judge of the elections, returns, and qualifications of its own members, unquote. In that case, Betty McCollum. In this case, it will be Senator Al Franken. if he wins, which at this point it looks like he might. And in 2012, the Minnesota Supreme Court wrongfully made this decision. Also, a contest was filed, and I asked that it be forwarded to the House leadership. And so then now they say that they're not going to look at it because of res judicata based on a theory that latches occurred in the 2012 petition. And it's not immediately relevant to this particular motion. So here's my argument. Here the Supreme Court of Minnesota insists, and the FCC has strongly implied, that Congress may pass laws for unfree, impure, and unsafe exercise of the right to vote. And I'm talking about that equal time provision, 315A, which they say they can use to control our elections for the United States Senate. And Al Franken and Lori Gildea and Larry Jacobs and the rest dance around this, and they've totally trashed our elections landscape. So that right, again, is the right to vote and the associated rights to be informed through hearing the debates, including in a publicly broadcast U.S. Senate debate involving all the major party nominees. Judge Monahan, in Moore, bemoans the circumstances he insisted required him to exclude James Moore from the Senate debate with Walter Mondale, who had just jumped into the race as the DFL champion. He cited CBS versus DNC, Democratic National Committee Supra, as saying that the FCC, quote, is charged with the duty of fairly and impartially informing the public audience, unquote. So that's what NPR intends to do, to, quote, fairly and impartially inform you by excluding me because of my Tea Party views or whatever their whole negotiated deal with Mike McFadden and Al Franken, and they call that fairly and impartially informing you. Well, obviously, it wasn't impartially because it involved the partisan candidates and viewpoint discrimination. But that same CBS versus DNC case continued, quote, the initial responsibility for fairness, balance, and objectivity lies with the licensee, unquote. Here, that's NPR Radio and WCCO, and it also includes KBJR, My9 TV in Duluth, but for the purposes of this injunction to the Supreme Court, that was not included. It will be included when it goes up again. Now, finally, the CBS court stressed that, quote, the role of the licensee as a journalistic free agent calls for a delicate balance of competing interests identical. Well, obviously, Al Franken is not doing any delicate balance. It is just that delicate balance and those competing interests which have gone out the window in this new scheme, which purports to give to Al Franken and Mike McFadden the ability to work out a whole campaign, pick the sites and favorable terms of these three different FCC licensees. And if the law allowed this in Moore, it does not allow it here. The petition, because there are exigent circumstances in Moore. The petition and FCC complaint go through how I exhausted the process and then sought judicial review and enforcement. They established that the events where my exclusion is challenged were indeed live broadcast political campaign debates, not documentaries or any of the exceptions under 47 U.S.C. 315. The only issues for this motion are: 1, do I have a right under the federal and state constitutions and law to participate in Sunday night's debate? And for declaratory relief, did I have such a right last Sunday morning at WCCL? And 2, is the Minnesota Supreme Court bound to police this practice in federal elections based on the state's duties found in the U.S. Constitution to prescribe the election of U.S. senators? In Carlson, this case, the court is presented with a different dynamic than in Yarborough. While in Yarborough, the state of Georgia saw the federal law against election beatings as infringing on its own power. In this case, the state of Minnesota refuses to enforce its own elections laws. That's Minnesota Statutes 204B generally, with 204B.44 providing for Supreme Court control of any errors, omissions, or wrongful conduct concerning a specific election. in Yarborough, in enforcing its own voting laws, Georgia did not want federal voting-based penalties for brutally assaulting and intimidating black voters. Here, NPR has both excluded and engaged in viewpoint discrimination against movement, an impermissible violation of the First Amendment freedom of political expression, seeking openly to suppress my views. And the state wants to allow this without review or control because, they say, it doesn't concern ballots or a challenge to Secretary Ritchie. The viewpoint discrimination of NPR is based on views they falsely attributed to me. For instance, NPR News spread all over the radio and internet an accusation that I said it was, quote, a valuable public service, unquote, to kill Trayvon Martin. What I did say is George Zimmerman, as a neighborhood watch person, was providing a valuable public service, unquote. The point is that NPR put this in a news story explaining why my win over the endorsed candidate, Kevin Terrell, CIA, credentials, and NSA, foreign policy credentials, has led to the Independence Party, quote, disowning, unquote, as if they ever owned me, isn't that funny, and making me unsuitable as a nominee. This was done at a time just after my election and before the first poll, and thus it affected that poll. I polled 13% against Franken and McFadden in July, as documented in the court below, even though the party had endorsed someone else. I did not seek party endorsement because I know for a fact the party leaders engage in viewpoint discrimination on the issues of so-called marriage and drugs, and also reference from Democrats election focus on racial scars, New York Times, the very day I submitted this, where today the New York Times reports this race baiting is being used by liberals and Democrats throughout the South. And in fact, the Trayvon Martin case was used against, I believe his name's Thomas Tillis, who's running in North Carolina, where they said he was responsible by pushing for stand your ground laws for the killing of Trayvon Martin, and this is why blacks should come out and vote for Kay Hagan. This is the kind of thing that NPR was doing. Al Franken does, but he doesn't have to do it because he's got his sidemen doing it for him, Mike Mulcahy and Larry Jacobs and the like. And so this top trending item on a Steve Carlson Senate Google search on October 30th was on an NPR news item saying, quote, IP insiders are aghast at the selection of Carlson, the Independence Party's candidate for Congress in the 4th District in 2010 and 2012. Among other things, they say, he has defended a Missouri Senate candidate's remarks about legitimate rape, unquote, alleged a war on white males, and said the person who shot and killed Trayvon Martin, quote, provided a valuable public service, unquote. None of these things are true, and I immediately and repeatedly sought to correct Tom Scheck, so-called journalist, to no avail. And Mulcahy, the news director in charge of the debates in this year, and also who moderated a debate I had with Betty McCollum in 2012, refused to accept my statement that Todd Akins never said rape is legitimate. He insisted Akins does say rape is legitimate, which is a false political polemic that you would expect of leftist political activists running so-called FCC licensee. Now, NPR uses their influence to smear me as a candidate, and now they exclude me from a publicly broadcast debate, in a scheme of 3 debates worked out with the Franken campaign to exclude me from all debates. This is viewpoint discrimination in violation of the First Amendment, because it is hardly believable the decision to exclude was not based in part on their false, disparaging misrepresentations of my viewpoints in suppressing them from the debates when they refuse to correct them. They want to protect their own false lies. They don't want to be caught being racist, race baiters in a Senate candidate debate, because that would smear their reputation, which I don't understand how NPR has a reputation. The Minnesota Supreme Court had jurisdiction over this matter under 204B.44. In her decision to throw out my elections petition, Chief Judge Lori Gildea elected, and then you should see what she did to her opponent, Joe Clark, just after the election. This is like Stalin. These people should not even be near a court, let alone elected to one. And you have made a gross mistake in electing these kind of people to our Minnesota Supreme Court because they corrupt your elections. But she said that, she falsified the law. She abused her power and discretion and clearly erred and acted contrary to law when she justified throwing out the elections petition saying, the one on these debates. This claim does not require consideration of the ballot, nor does petitioner allege that any Minnesota election official had any duty concerning these debates that can be corrected under 204B.44, unquote. This is, in fact, an example of an omission by a judge. She omitted this claim, which needs to be included. And unfortunately, this is a trend of the court. The implication that because she picks out two things which the petition is not, that it therefore follows that whatever it is falls outside the whole 204B.44 is completely illogical. It does not follow, and the wrongful omission and exclusion from debates for an entire campaign season clearly falls within what this court should consider as the scope of, and I'm talking about the U.S. Supreme Court, Minnesota Statutes 204B.44 as part of the, quote, elections for senators and representatives which shall be prescribed in each state by the legislature thereof, unquote. The judges themselves, all elected, cannot simply stop short of fulfilling their critical duties with such silly self-limitations. See Sprint Communications versus Jacobs from 2013. Federal courts, it was early and famously said, have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given, unquote. Citing an 1821 case, Collins versus Virginia from 6 Wheaton 264. Jurisdiction existing, this court has cautioned, that's the U.S. Supreme Court, a federal court's obligation to hear and decide a case is virtually unflagging. That's Colorado River Water Conservation District versus the United States from 1976. That if you want to look it up, it's 424 U.S. 800. I do not say Colorado River binds the Minnesota Supreme Court in the same way it binds federal courts. However, I argue as best I can in this limited time that the duties they exercise come from the United States Constitution because it mandates that the senators be elected as prescribed by Minnesota state law, and this inevitably requires that the Supreme Court exercise whatever jurisdiction is required to meet this. Again, had the legislature actually said, we're going to limit your jurisdiction to ballot tampering, anything else is fair game in elections, they would have fallen short of prescription. Therefore, the limitation would be unconstitutional, as is the refusal to exercise jurisdiction over this debate question. Because as this court, United States Supreme Court, said in Forbes, the role of campaign debates is so crucial. The district court in Moore had jurisdiction over the debate and deferred to the licensee. That is WCCO and NPR wrongly, I would argue, but I don't want to dwell on Moore too much here. Well, in that case, it was NPR in Moore. And it's absurd to argue that the Supreme Court of Minnesota itself would be without equal jurisdiction to this district court, Monaghan, of the Ramsey County District Court, for federal and statewide races. Clearly, they share the same jurisdiction. And clearly, it is in Minnesota Statutes 204B.44, as I point out. And yet, Judge Gildea constantly misstates it as if 204B.44 is only ballot related. It cannot be, because in addition to the specific plans for all the counties and Secretary of State and the canvassing board, Minnesota's legislature needs to make sure, like the Congress does, that the election is free, pure, and safe, and they're making it corrupt. It's unfree, unpure, and unsafe. And those words come from Yarborough, not my opinion. And the Minnesota judiciary needs to enforce it. And they can't do that if they signal to contesting parties that they will do nothing about anything except the ballot or the duties of Mark Ritchie himself or some elections official. The Minnesota court, in its decision By the way, an elections official would not have covered these people who were beating up the Georgia black voters. And so it would have been unconstitutional in Yarborough as well. So the Minnesota court, in its decision on my 2012 petition, usurped power they didn't have. And again, violating what was said in the Sprint and in Coens versus Virginia and the Colorado River cases. The electoral lawlessness also reaches the state's chief elections official, Secretary of State Mark Ritchie, who's resigning, since he brought voter email addresses home for use in his campaign, including fundraising for his own campaign. It was determined they were public information. In 2012, I tried to present the issue of the barring of the voter email addresses. They have been offered to me by the OSS office, and I finally determined to use them as part of my campaign, and then they were withheld after that. And I tried to bring this to the canvassing board before they certified the election. It was given to Ritchie, the head of the board, but I was told the complaint was not forwarded to the canvassing board. Therefore, I had to file an elections contest. I wanted to void the election, and the state process was the only one that could do that, and the canvassing board failed me. So I filed under 209.01 and also specifically 209.12 congressional offices. It could not be voided in any Minnesota court, but the process leading to consideration by the U.S. House went through these state laws, not the federal court. And the other issue I felt spoiled the election was the use of proportional representation or quotas, gender, race, sexual preference, etc., by the DFL in endorsing candidates and positions, and exclusion from precinct caucuses for those who disagreed, although the right to attend the precinct caucus is guaranteed in the Minnesota Constitution. That is not a factor in this motion for injunction. In that instance, what happened is that the same court, with Gildea as its head in 2012, usurped the power of the House of Representatives by preventing the taking of evidence for the U.S. House to decide whether in a race where Representative Betty McCollum had publicly called for the withholding of voter email addresses from her opponents, the House could decide whether that kind of First Amendment violation was a problem in campaigns for its member elections. Who knows what they'd say? Clearly, the Gildea Court's rulings on elections have little or nothing to do with the appropriate exercise of jurisdiction, and everything to do with the outcome she and the other judges desired. And now, in the decision appealed from, they say it was already decided by the federal court. Also, a timely filed petition for rehearing in that case was just denied September 25th, 2014, and is ripe for appeal here, and therefore res judicata. But now in 2012, the Minnesota court barred that claim supposedly for laches, not because it was not timely filed, but because I had filed it within 2 days in 2012 in the federal court. 2 days after I found out they would not give me the email addresses, I acted. And they supposedly dismissed it for laches. Obviously, a laugh out. And they said because I filed it with the federal court and not with the Minnesota Supreme Court, it was laches. But now at the same time they argue if I did file it with them, they would not have had jurisdiction over it because of its subject matter. So it couldn't have been laches not to have filed it with them since they claimed they didn't have jurisdiction. This is monkey business. And I am asking the Supreme Court of the United States to act to preserve as much of my rights as possible at this date, and then I am going to bring the case for review if you accept it. Duties of the state of Minnesota set out in the Forbes decision. Since it is clear that the 204B.44 petition is the police power, is within the police power of the state for federal elections errors and the constitutional power, and omissions and wrongful conduct, including publicly broadcast candidate debates, the court might ask, what is the state's role? Well, in Forbes, it was stated that the First Amendment will not tolerate a state agency's arbitrary exclusion from a Senate or a debate forum based, for example, on an expectation that the speaker might be critical of the governor or might hold unpopular views about abortion or the death penalty or homosexuals. Indeed, the court so holds today. and this statement was written by the dissent. It seems equally clear, however, that the First Amendment will not tolerate arbitrary definitions of the scope of the forum. We have recognized that once it has opened a limited forum, the state must respect the lawful boundaries it has itself set. Now remember, in Forbes, the publicly broadcast debate was actually run by a board of commissioners appointed by the governor and other members of the Arkansas legislature themselves. So that was obviously state action. Now it follows, I argue, that a state's failure to set, it was argued in the Supreme Court dissent, follows that a state's failure to set any meaningful boundaries at all cannot insulate the state's actions from First Amendment challenge. The dispositive issue in this case, then, is not whether AETC, that's the Arkansas Educational Television Board, whatever commission, created a designated public forum or a non-public forum as the court concludes, but what's important is whether AETC defined the contours of the debate forum with sufficient specificity to justify the exclusion of a ballot qualified candidate, unquote. This is the issue I am raising here. Must the state, talking about Lori Gildea, the Supreme Court, the legislature, in implementing its prescription of the election of U.S. senators, defining the contours of the candidate debate fora with sufficient specificity to justify the exclusion of ballot qualified candidates, and in this case, major party nominees? I argue that they must maintain their own boundaries as set, and they must be set by the First Amendment. And the Minnesota Supreme Court is not, as they insist, insulated from the issue of making sure these debates are constitutionally conducted, just because they claim the statute doesn't include the issue, which it does. Minnesota has obviously not taken jurisdiction to control this, and you cannot elect U.S. senators this way in Minnesota. They are outside and above the law. Al Franken, Amy Klobuchar, and Betty McCollum. Although Betty did not exclude me from publicly broadcast debates, but these are statewide. And these debates would keep the party on the ballot. And now the major party factor deciding whether to exclude a nominee from a publicly broadcast Senate candidate debate. 6 weeks before the 1998 gubernatorial election in Minnesota, the Star Tribune pegged Reform Party candidate Jesse Ventura at 10% in the polls. 3 debates later, on October 20th, he was at 20%. Remarkably, Ventura's cash-strapped campaign had not yet aired a single television advertisement, one of those nice little 30-second sound bites that Franken and McFadden are polluting the airwaves with. On Election Day, Ventura captured 37% of the vote and became governor of Minnesota. Governor Ventura explained his astounding victory, quote, "I was allowed to debate. I proved that you could go from 10% to 37% and win if you're allowed to debate. Rest assured, these two parties don't want to ever see this happen again," unquote. And I'll point out, too, that when you have 3 parties in, you can win with 37%. So if I could get in 3 debates, push this into a 3-way race with McFadden and Franken, if they had followed the First Amendment, I could have done the same thing Ventura did, because I can definitely out-debate Al Franken or Mike McFadden. Now, with Jesse Ventura, I'm not so sure. Truer words by Jesse Ventura were never spoken. That was 1998, and it was in 2002, with the tragedy of Wellstone, that a Minnesota court began this exclusion, not even considering the major party status. But I argue it is a central factor. The manner of election of U.S. Senator is prescribed in part as follows. As I set out above, 204B.03, manner of nomination provides that candidates of a major political party for U.S. Senate shall apply for a place on the primary ballot by filing an affidavit of candidacy and shall be nominated by primary, which I did and won the primary. So this law and the existence of the Independence Party create a constitutional requirement for freedom of association under the First Amendment U.S. Constitution. And a string of cases, including Tostian versus Republican Party, 1986, that's 479 U.S. Reporter, 208 if you want to look it up. John Anderson versus Celebrezze, 460 U.S. 780, 1983, and Ale Fung versus San Francisco County Democratic Central Committee from 1989. These have mapped out the implications of this right of freedom of association that inheres in parties. But to describe the rights secured to the IP and its nominees, I'll just cite from Tostian. Quote, the freedom of association protected by those amendments, this is the First Amendment, includes partisan political organization. Section 9431, that was the decision of Tostian that you had to register with the Republican Party before your vote could be counted in the election. This is what the Democrat Party does. This is your Democratic Democrats. They said that it placed limits upon the group of registered voters whom the Republican Party, could invite to participate in the basic function of selecting the party's candidates. The state thus limits the party's associational opportunities at the critical juncture at which the appeal to common principles may be translated into concerted action. This is what the IP exists to do, and hence to political powers in the community. The fact that the state has the power to regulate the time, place, and manner of elections does not justify, without more, the abridgment of fundamental rights, such as the right to vote for, or here the freedom of political association. Unquote. Now, in Tostian, the burden on this First Amendment right, which must be justified, is that to vote in the Republican Party, voters had to register with the party. In this case, it is that the nominees of the party must attain some comparable poll numbers, not including the undecided, in order for these broadcasters to choose to let them in a debate. And otherwise, the Democrats and Republicans can just go about and set up their own debates for the whole season just so they can, pursue their own advantage. If one's in power, they can stay in power. If the other one challenges them, they can get a clear shot at them, excluding people like Jesse Ventura or Steve Carlson. So we see the burden demonstrated when we see the impact of Jesse Ventura from being in the debates. 3 of them, and becoming governor with very limited finances and starting at just 10% in the polls. And what I'm arguing is that because this is a major party, in this case, this burden violates the First Amendment requirements of Tostian and these other cases based on this court's freedom of association cases. And all of these people all involve the freedom of political expression. The Independents, DFL, and Republican parties all hold primaries for U.S. Senate under this law. The FCC argues any of its licensees are under the Communications Act free to limit publicly broadcast debates to just 2 of the major parties. But hey, this is the FCC. Who gave the FCC the right to regulate elections? Nobody. The Congress did not, it could not, and Minnesota Supreme Court are corrupt when they allow this to go on because they have to enforce these same rights in Tostian, and I believe that when I go to the U.S. Supreme Court with this, they will rule in my favor. I asked lawyers all over this country to join with me and write amici curiae briefs to the United States Supreme Court. I will contact each one of you and try to enlist you. I'm not a lawyer, but you are. Okay? So, the FCC, however, argues any of its licensees are under the Communications Act free to limit publicly broadcast debates to just 2 of the major parties. This appears to be based on poll numbers, which can have the same poll test of the Independence Party that you do of the independent candidates in other states. The poll numbers of the 3rd major party are inevitably going to be limited. They just haven't built that base. That's why they're called a major party and allowed to get in with 5% in a statewide election. And their real base, although there is an ideology of radical centrism, which I represent, is those disaffected from the major parties. But most telling, the turnout for IP primaries is limited to only those who eschew all voting for any DFL or Republican candidate in any race in the state. So while I polled 13% against Franken and McFadden, if the general election were held July 2nd and 3rd of 2014, and it wasn't held then, it was held months after a primary, and in that primary, rather predictably, only less than 3% voted for IP candidates. But this doesn't mean that I all of a sudden fell from 13%, so the poll are simply wrong. And they can't be used. But even if they could, it would have to be justified as a First Amendment burden, which it will have to be in the United States Supreme Court, NPR and WCCO, and the FCC. But the FCC decision here seems very generic, not poll-based, and it was accepted, and I'm going to read what it is, was accepted without question by the Minnesota Supreme Court as governing our Senate candidate debates. And here's what they say. That's because broadcasters enjoy freedom of speech under the First Amendment. Okay? And the FCC is prohibited by statute from censoring or dictating program content. The result is that stations can carry pretty much whatever and whomever they want, short of obscenity or indecency, even if the material is false, misleading, or slanted. Therefore, if the station chooses to include only two of the candidates in the debate, it can do so, and the FCC cannot tell it to do otherwise. Well, then, I guess the FCC's jurisdiction does not really reach to deciding publicly broadcast debates, does it? It only reaches to the First Amendment rights of the broadcasters. They can't say, therefore, I don't have First Amendment rights, or you as voters don't have First Amendment, or even fundamental rights of electing a new government. So this regime is different from that in the DNC case, where the FCC was found to be charged with the duty of fairly and impartially informing the public audience, unquote, because here they have no duties, and here the FCC cannot tell WCCO or NPR what to air, where apparently in DNC only they could. So in fact, nobody can. Right? But the actual language of Section 315 is that they indeed do not need to air the debate. I'm talking about WCCO and NPR. But if they do, they have to treat me equally, that is to say, include me. And that's in 1 hour. And I'm going to go see if they're going to include me. So on the issue of the jurisdiction of the state under this FCC ruling, it does not appear that the FCC has any preemption over the issue of the conduct of the election. And yet this debate is part and parcel of the election. Here's what the Supreme Court said about debates in Forbes. Quote, although public broadcasting is a general matter, does not lend itself to scrutiny under the forum doctrine. Candidate debates present a narrow exception to the rule. For two reasons, a candidate debate, like the one at issue here, is different from other programming. First, unlike ATC's other broadcasts, the debate was by design a forum for political speech by the candidates, by me, not by Mike Mulcahy. Nobody wants to hear what Mike Mulcahy has to say, but you should be able to hear what I have to say. Consistent with the long tradition of candidate debates, the implicit representation of the broadcaster, before this by Mike Mulcahy, was that the views expressed were those of the candidates, not his own, and they can't censor those directly under the equal protection. They're barred from censoring. The very purpose of the debate was to allow the candidates to express their views with minimal intrusion by the broadcaster, Mike and Tom Scheck. In this respect, the debate differed even from a political talk show, whose host can express partisan views and then limit the discussion to those ideas. And I think really that is what's happening in many of these so-called debates. But they're billed as debates. So Esme Murphy has got a little talk show there, but they call it a debate. And Mike McFadden and Al Franken call it a debate. Now Mike Mulcahy's got a little left-wing Al Franken, Stuart Smalley type of political talk show. So second, goes on to Supreme Court, in our tradition, candidate debates are of exceptional significance in the electoral process. See, they're part of the electoral machinery. Quote, it is of particular importance that candidates have the opportunity to make their views known so that the electorate may intelligently, NPR is intelligent, right? Evaluate the candidate's personal qualities and positions on vital public issues before choosing among them on election day. Deliberation on the positions and qualifications of candidates is integral to our system of government beyond elections, and electoral speech may have its most profound and widespread impact when it is disseminated through televised or radio broadcast debates. A majority of the population cites television as its primary source of election information, and that's got to change to the internet. And debates are regarded as the only occasion during a campaign when the attention of a large portion of the American public, and I would say electorate, is focused on the election, as well as the only campaign information format which potentially offers sufficient time to explore issues and policies in depth in a neutral forum, unquote. This is from Congressional Research Service, 1993. And I would say also see Buckley versus Faleo. So clearly, the Minnesota Supreme Court errs when they reason, if that is, that the FCC has been given by Congress preemptive powers over campaign debates publicly broadcast. That is because the practices of the broadcasters may also impermissibly burden the rights of a Minnesota major party and its nominees under the First Amendment, freedom of political expression. Therefore, it is the Minnesota judiciary who must assert the powers of the state to prescribe and carry out the election, including the constitutionality of campaign debate practices. And then I go into weighing the 5 Dahlberg equity factors, which I'm going to leave out right now because I have to get to the campaign. I'm Steve Carlson. Thank you for watching, and I approve this. And I want to win in the Supreme Court to protect your rights and mine and save free and fair elections in our Republican form of government and our democracy in Minnesota and in the United States.